Hi everyone, Marissa Streit here, CEO of PragerU, and I am here at our Prager University offices. We have a very special treat today. We are celebrating 1 year since we filed our lawsuit against Google YouTube, and our lead attorney on our very important case is here, Peter Obstler. We're very excited to have you. I'm excited to have this conversation with you, hear a little bit about the updates, the inside and outs about the case. But first, I just want to go into some personal issues. Tell us what brought you here? Why have you decided to take on our case?
Well, first of all, let me just say thank you, and what an honor it is to represent Prager University on what I believe is one of the most important First Amendment cases that I've certainly ever handled in my career, and I'm very grateful for that opportunity, so thank you. What brought me to this case was, well, there's an old saying, what makes a good lawyer is a good client, and I was particularly attracted to the fact that I really thought you were being treated very unfairly. I have a long history of doing First Amendment work. I was the lead lawyer for the city and county of San Francisco on the Mount Davidson First Amendment cross case, which was not dissimilar to this because it involved a state action issue. I've represented rock and roll promoters and other clients who need to get licenses for First Amendment types of activities. And I've always believed that of all the amendments in the United States Constitution, the First Amendment is the one that is at the most essence of what it is to be American, what it is to be free speech, and what it is to be human and rational in an evolving, enlightened society. So the opportunity to litigate a First Amendment case involving the internet obviously was extremely attractive, but the thing that got me the most is I just think you're being treated really unfairly, and I think it's really outrageous what's going on in this case, and so there's a sort of passionate element to it too.
Well, I want to thank you. Governor Pete Wilson is the person who introduced us. So I want to take a moment to also thank Governor Pete Wilson, who assigned you onto this case. Something very interesting about you is that you're actually not a conservative. Is it fair to say that you're a socialist?
I've tried not to identify with terms of isms, but I will say that I probably come from the more left part of the spectrum. I'm a former community and union organizer. I was a VISTA volunteer. I've done welfare rights work, so that's been a lot of my actual work. And in terms of my political beliefs and values, you know, I don't agree with a lot of the stuff that are in the videos, but I certainly agree with your right to express them, and I certainly welcome the opportunity to engage with you on those issues. I've always said that one of my biggest heroes in this day of partisanship is Bill Maher, because he doesn't ban Steve Bannon from coming on his show. He says, Steve, come on the show, and I'm going to tell you why I disagree with you, and you're going to tell me why. And we both come out better, and I think in the end, we also end up realizing how much we agree upon.
Right. So that's, I mean, such a basic American value, right? I don't have to agree with what you have to say, but I will literally, in your case, defend your right to say it. So, I applaud you for that, and it's such a great thing to see that people from across the aisle are working together on this issue. So not necessarily for me, but mostly for our audience, what is our elevator pitch? What is the basic idea of this lawsuit?
The basic idea of this lawsuit is that internet social media sites who monetize free speech by inducing the public to come and use the platform on the promise that the platform is a public forum for freedom of expression have to comply with the basis of that promise, which is that you have to comply with what it is to engage in free expression, and that is defined by the First Amendment. So you can't tell somebody, for example, I'm selling you, and we've used this example before, but I'm selling you red wine from Napa when I'm getting you grapes from Paso Robles. It's not that Paso Robles doesn't make good wine, but I was looking for Napa wine. And when you consider that they built the largest video platform in the world based on the representation to people, including people like you, please give us your speech and your well thought out videos because we are a public forum for freedom of expression where everybody is treated equally. We expect that to be the truth. We don't expect to get censored or restricted simply because you don't like the viewpoint or the political ideology or religious ideology of the speaker. You have to keep the focus on the content. And I've reviewed all of your videos, and I have no problem with the content. I don't agree with a lot of the viewpoints that are expressed, but I couldn't think of anything that would be more protected than your videos. So the fundamental issue in this lawsuit is, does First Amendment protection apply at all? Or because they're a private actor, are they free to do what they want to whoever they want, whenever they want?
So it's almost kind of like it's like consumer fraud. It's like bait and switch. They told us when we created our channel, and they tell the consumers that this is a public forum, yet they don't treat their own product as a public forum, and in that way, it's deceiving the audience of what their product really is. Is that right?
That's absolutely right, and that's extremely well put. And it's particularly dangerous in this context because it does involve free speech, because they monetize free speech. They are a multi-billion-dollar corporation whose entire product is free speech of others. They built this platform on the backs of people like you, and they did so by saying, come give us your speech. We are a place for freedom of expression. If they didn't make that representation, I don't know whether they would have built the platform as big as they did, but I think there would have been competitors, because I think there would have been other people out there who would have said, and there will be other people out there who said, we're prepared to go the full way. We're prepared to give you the protection that you want. And the other thing I just want to say on this is it's not only devious for making a lie to consumers. Also, in the case of PragerU, based on our comparison, I mean, there is a real discriminatory element. So regardless of whether they're a state actor or not, as you know, we have claims for discrimination under UNRUH Act, we have breach of contract claims, and we have unfair advertising claims. But as to the breach of contract claim and the discrimination claim, those are claims that are really, really important in this case, in addition to the First Amendment cases, because we've compared your videos to other videos. And there's no rational reason why you would be restricted for the reasons that they say you're restricted, and they're letting other videos go. I mean, if I see one more video about why it's okay to punch a Nazi that other people are putting out that goes unrestricted, and then I look at your video on fossil fuels, which I might not agree with, where the content is absolutely perfectly fine, and you are restricted, you know, my jaw drops when I see that. I just think that's just really unfair. It's really deceitful. And it also results from a conglomeration of power in one area that is very, very dangerous. You know, there's an old saying, I think it was said by Herbert Hoover, but it may have also been endorsed by Frederick Douglass. I'll have to check that. But I can tell you what the saying basically is, which is dictators always rise to power by always championing free speech. And then when they get power, they censor you. And that is exactly what's happening here. YouTube has gotten to power by basically telling everybody, we are a public forum for freedom of speech, and then turning around on the back end because they're concerned about advertisers, maybe they've got commercial goals, or maybe they just don't like you, and censoring you for reasons that are absolutely impermissible and discriminatory and are based on animus.
You touched upon the breach of contract a little bit. Can you explain that a little bit better? And also, the way I explain it, and you can go into the legalese a little bit better, is Prager University opened a channel on YouTube years ago, built an entire business model based on the contract that we signed with them when we opened the channel. This same contract was given to multiple other vendors who opened channels on YouTube, but we have been treated differently from the way others have been treated. Is that a correct way of explaining this?
That's a correct way of saying it. I think and in fact, that is the upshot of what we will prove. The actual legal claim is that the contract is inconsistent, that the contract incorporates, and we're talking about terms of use, right? Every user has to agree to terms of use. And the terms of use on the one hand say, we reserve the right to censor anybody for any reason at all. At the same time they're doing that, they have community guidelines, which I believe we are in full compliance with. And they're also telling people—
Except for the porn, right?
Right,
yeah.
right. and I haven't seen that video yet.
No,
yeah.
no.
The other point is the representations of the mission statement, which are all according to their terms of use contract incorporated. So now you have these inconsistent provisions, right? On the one hand, freedom of expression, this is the criteria, we apply it equally to everybody. Oh, and by the way, our algorithms and our machines that do this are content neutral. We never look at that. And that's going to be interesting because I'm going to really want to see the code in those algorithms to see if that's true.
Yeah, well, algorithms are written by humans
exactly.
who can produce whatever results they want anyway.
And are changed weekly.
Right.
And are changed weekly. So on the one hand, you have that. And on the other hand, you have that line at the bottom, we reserve our right to do anything to anybody at any time. That's what you call when one provision is used to supersede the intent of the other provision, and you've got inconsistent provisions, not a pure express breach of contract, but a breach of the implied covenant of good faith and fair dealing. Every contract has an implied covenant of good faith and fair dealing. We see this most clearly with the mortgage crisis. Banks had provisions that said they could change mortgage rates, et cetera, liability provisions that they weren't liable for all over the place in their contracts. They had disclaimers all over the place. But the court said, well, maybe it's not a technical breach of that provision, but the implied covenant of good faith is that you're going to treat people fairly and fairly and equally, and you're not going to use that to discriminate or harm them for your own advantage simply because you can manipulate your contract. And that's the theory of the breach of contract claim. It's more of an implied breach. I think that they are right in the sense that they say we have this line at the bottom, but at the same time, they have criteria that we comply with. And at the same time, they're telling you it's a public forum. So what provision controls? I think the courts look at that and say, is this being consistently and fairly applied in good faith for the right reasons? And we know that there's already been a case that has found that the YouTube Google contract, I believe, I apologize, it's Twitter. Twitter's
right.
contract has been found to violate the implied covenant of good faith, at least on its face of the pleadings, because of that exact inconsistency.
So these social media platforms can't just say, well, here is a contract. This contract says we can do whatever damn we want to do to you.
Right.
That is something you can't sign your life away if that's essentially what they're expecting, or allow them to treat you however way you want.
And that's a fundamental rule of any consumer product. Again, I come back to the foreclosure and the housing crisis. I mean, all the banks paid huge amounts of money, in large part because the contracts were inconsistent and applied in ways that were discriminatory and unfair to people. It's no different. Every consumer product where you sign a contract, every contract has an implied covenant of good faith and fair dealing. And if you manipulate one provision of the contract to supersede the intent of another provision of the contract, that's not good faith and it's not fair dealing.
I want to go back to the public forum idea, because that's really the crux of the case, a big portion of our federal case. Where does the issue of restricting free speech come in? Could someone say, well, YouTube is protecting the public from horrible things like terrorism and pornography? Can't they? Where does it end? Is there a line that we draw where we say, well, YouTube a parent has a choice to make. If they don't want their children to watch pornography when they're surfing YouTube, they can click on restricted mode and they won't watch pornography. Isn't that their freedom, where they would be allowed to do this kind of stuff in order to protect the consumers?
Yes. But what you can't do is restrict some pornography and other pornography because you don't like the political viewpoint of one pornographer, but you are okay with the political viewpoint of the other pornographer. And that is the crux of this type of First Amendment restriction. Again, we have to distinguish between two very important issues, and this is something that I think everybody really needs to understand. We have to decide, does the First Amendment apply, first of all, which is an issue of state action. If the First Amendment then applies, we can have a fight like the one, and a fight maybe not the right word, maybe just a discussion about what speech is protected and not protected under the First Amendment. The courts have been very diverse in their views on that, and it's very factual and contextual. YouTube and some of our other industrial opponents in this case would like the world to believe that the First Amendment means anything can go. The First Amendment doesn't mean that anything can go. If the First Amendment applies, which they're saying doesn't apply. What they're really saying is we can do anything we want, but you can't. But assuming the First Amendment were to apply, their fear would be that everything would go. And I think that that's the concern that you're articulating here, right? But that's not true. That's not what the First Amendment does. The First Amendment only protects certain types of speech and only in certain contexts. So you have to determine, is the regulation content-based? Is the regulation a time, manner, place restriction? And then you apply a level of scrutiny. The fundamental view is this. You have to have a compelling interest. You have to have your restrictions to be as narrow as possible to achieve that interest. And you can't have vague or ambiguous criteria that gives you an unfettered discretion to decide what you want to allow to go forward and what you're going to censor, and use the criteria as a pretext to censor somebody for an entirely different reason. The most classic example is YouTube and Google's reasons that they're censoring your videos. They don't give a specific reason. They just say, we don't like the topic and we think it's inappropriate. Well, that goes against what they're promising. The user should be able to decide that by simply saying, we're not watching that video. But if the content is compliant, the actual underlying content is compliant, because you don't like the viewpoint, then that's not a basis for censoring it. Remember, popular ideas don't need the First Amendment. It's unpopular ideas that need the First Amendment.
Well, and our ideas, unfortunately, are unpopular at universities, so they don't like what we're doing. The million-dollar question. Are we advocating for more regulations?
This is the question that really drives me, I don't want to say crazy.
Nuts!
Nuts, right? Yeah. This is the question that is such a straw man or straw person, I guess I should say. But the point being is that, look, we're doing the exact opposite. The First Amendment is part of the Bill of Rights. And there's a reason why free speech and freedom of expression and freedom of religion is the First Amendment. I mean, they didn't sit there and just randomly pick them out of a lottery thing like an NBA draft and say, you're going to be number one, and then there's going to be the Second Amendment and the Third Amendment. The reason the First Amendment is there is because free speech is the fundamental foundation of America. We are much more progressive on that issue than almost any democracy in the world. But everybody will tell you that the essence of an enlightened, civilized society is the ability, even if we disagree, even if I find your viewpoint offensive, to be able to engage in expression. I'm not talking about acting upon the viewpoint. I'm talking about the ability to communicate the ideas. So what the First Amendment does is it stops government regulation. It stops people from being able to regulate that. They are putting more regulation on you than they are allowed to do. Now, the argument is, but they're a private party. I agree. But if you're a private party, then don't hold yourself out as a public party. Because when you say to people you are a public forum for freedom of expression, the law is clear that only the government can regulate that type of speech subject to the First Amendment. In other words, they're stepping into the shoes of the government by going out there and inducing people to post stuff that they can profit from on the promise of being a public forum. I understand if the private property owner doesn't want that restriction. But who better than the private property owner, especially in a free society, to say, I don't want this restriction. I'm going to be honest with the consumer and say, we're not going to do this anymore. We're going to de-designate. We are not a public forum. That's what we're talking about, is the private property owner has the choice here. So this is the opposite of government regulation. But if you're going to try to sell me Bronco wine and that says it's Napa wine, and it turns out to be from some other place, that's consumer fraud. And the people that are using that product, who are induced to purchase that product, believe they're getting one thing and they're getting something else. It's a bait and switch. What's fascinating about the way YouTube's trying to split this issue is they want it both ways. They want to induce people to use the platform as a public forum, but then they want to regulate speech in a way that's entirely inconsistent with the way speech is being regulated in a public forum. So the answer to everybody out there who thinks that this is a case about government regulation, no, this is a case about fighting government regulation, and the mere fact that the private party is performing a government function is the problem of the private party. Don't perform that function, tell people the truth, and there won't be a First Amendment fight here.
It's essentially a case about transparency and honesty, where both the viewers of YouTube and the content publishers who publish videos like ours on YouTube are essentially being deceived,
right,
by what they're producing. How do you think this case ties into what we're seeing in social media in general right now?
That's a great question, and that's more than a legal question. So hopefully, I'm going to step out of my shoes a little bit as a lawyer. But let me say one thing about the First Amendment. The First Amendment's very interesting because it's all about whose ox is getting gored, right? You know, let's just assume, I'm not saying this is the case, but let's assume what we believe, which is that in your case, it appears to be that the conservative, and I think the pretty mainstream conservative views and viewpoints that are expressed in what is otherwise appropriate context seems to be an issue that YouTube has a problem with, either for its advertisers who may come from the other side of the aisle, or people like me even who look at your videos and say, well, I don't agree with that. But
the left fights hard. That's what we say, right?
Well, both sides fight hard. But the point is that when Rupert Murdoch comes and buys Google YouTube, everybody on the other side of the aisle is going to be screaming about this. We cannot let this happen. Again, dictators rise to power by championing free speech, and then what they do is they turn around and they censor it. And that is precisely what's going on here. You built a multi-billion-dollar industry, not just YouTube, Facebook, Twitter. They do tremendous things for our society. okay? But they're also for-profit entities. And they're using this whole free speech issue to further their own financial goals. That's okay. I mean, that's not as bad as if they use it for political reasons. But the bottom line is, don't go into the business of free speech monetization if you're not prepared to live with the rules of free speech. And that's what this fight is all about. Justice Kennedy said it best. He said it best in ACLU versus Reno, and then subsequently in, I believe it's North Carolina versus Packingham. He said the largest soapbox, public assembly area in the world is now social media. And it's probably the largest soapbox or area for free expression that's ever existed in the history of the world. If you're going to build a platform that does that, you should at least abide by the principle that underlies that fundamental freedom of expression. And I worry about what I call the clampdown, because I've seen it on the left and I've seen it on the right. And for those of us who are out there who like to think we don't identify anywhere, but we're out there championing the civil rights of the individual against a large power, I am very worried about what's going on with speech. Now, I'd like to make one last point, because I'm going to get this argument in the case, and that is the slippery slope. Oh, come on. You've got all these horrible people out there. I mean, I hate to say it, but I'm going to use Alex Jones as an example. I get that all the time. Look, much of Alex Jones's speech is not protected. He's already been found, at least on the face of the complaint, to have made statements that are defamatory. Defamation's not protected, securities fraud is not protected, unfair advertising is not protected. None of that stuff can go on the internet. It's not protected. The laws protect that. Pornography, violence, threats to national security, all of that stuff is not protected. What you can't do is censor Alex Jones because he's Alex Jones. Supposing Alex Jones wants to come on and put a video on why the Mets need to go out and get Clayton Kershaw this year. I mean, sports. Or Rush Limbaugh, right? I mean, he's a guy who used to be a play-by-play announcer. I mean, are you going to censor him because he's Rush Limbaugh? No, you have to focus on the content. And I think the internet companies have gotten away from that. And I also think that while there is a problem with fake news and bots and all that stuff, which can easily be censored, and obviously a robot doesn't have a First Amendment thing, what you can't do is use that to clear your platform, because you're now going to get into content production and you need more room on your own platform and you don't want to give that money away. That's anti-competitive behavior. And there's a lot of that going on the internet.
Well, the slippery slope part is also the whole concept of hate speech. Right? Oh, well, it's hate speech, so I have to censor it. Well, what is hate speech? Well, if I don't agree with you, it's hate speech. Right? You gave me the example of if you go to a game, a baseball game, and you're rooting for a team that nobody likes, they're going to claim that it's hate speech because they don't agree with what you have to say.
Right.
Hate speech is not what I don't agree with. Hate speech is actual hate speech.
Yeah, and I think this is the hardest part for lawyers, judges, and all of us, for human beings to understand about the First Amendment. And it's the part about the First Amendment that can be very controversial. Because viewpoints, in my view, can be offensive. But the difference is, if the viewpoint is offensive, the remedy isn't censorship. The remedy is to persuade somebody that their viewpoint is offensive, or simply say, I find your viewpoint offensive, I'm not going to engage with you anymore. It's not to censor you. Mm-hmm. When you get into censorship, and I like to say this to a lot of people, when you get into censorship and you want to know what the difference is, read Alexander Solzhenitsyn's The Gulag Archipelago, and you will fundamentally understand the difference.
Well, this is why Dennis basically started Prager University, right?
Right.
That's exactly his biggest
fear. And it's autocracy. We can disagree all day about issues. I've learned a lot from Prager University. And I also have to say how, not just nice, but how intelligent I think you people are. But I don't agree with you, you know? The other extreme might be, let's face it, Kyrie Irving is accused of saying, or not accused, has said that the world is flat. That's Kyrie Irving's right. I can go to Kyrie Irving and say, you're a moron, the world isn't flat. That's my First Amendment right. Maybe I can't use the word moron. Maybe that's hate speech. But the point is, you focus on the content of the speech. Don't focus on the viewpoint. I understand to everybody out there that viewpoints can be offensive. I find many viewpoints offensive. But your remedy is to come back and fight the viewpoint with an alternative viewpoint and persuade. Because the only choice or the only alternative to that is outright civil war, dictatorship, fascism, and ultimately the Gulag.
So basically our case is viewpoint censorship, right? Is that viewpoint discrimination?
It is. Well, now we're going to get back to technical legal issues, but it is as to one of the claims, which is putting aside whether their criteria on its face would pass scrutiny under the First Amendment. They're applying it to you in a biased way. Mm-hmm. So as applied to your viewpoint, yes. But there's a second issue, which is the entire criteria on its face allows them to do that to you because it's so vague. Words like inappropriate, offensive. What does that mean? Some things that are offensive to you might not be offensive to me. You've got to point to actual content that would serve your compelling state interest, because otherwise that criteria becomes a pretext to censor you potentially on your political viewpoint, but it could also be for commercial reasons. I will tell you that I think a lot of the censorship is not going on for political reasons. They're portraying it that way to keep certain people on certain sides of the political aisle happy. But in fact, this is all a commercial gain because they're moving from being a third-party hosting platform to content producers, just as Netflix and other publishers have done. The problem is, unlike Netflix, they built their platform as a platform to be a public forum for freedom of expression. That's how they built it. And now they've got to try to get out of that if they're going to get into content production. But yes, at the end of the day, what we're saying is it's not about the content. It's some animus towards either the viewpoint or the identity of the person making the speech. Does that?
Yeah, clear to me.
Okay.
Let's talk about timeline. So it's been a year since we filed our lawsuit. Where are we now on the federal case? What do you expect to see in the near future? And talk a little bit about the second case that we're filing right now, which is in state court.
Sure. And that is a really, really important question because I have run into people who said, "Oh, I thought the PragerU lawsuit was dismissed and it's over." So let me just tell you and your audience sort of what actually has happened and where we're going with that. So we filed a lawsuit that had two federal claims, a federal First Amendment claim and a federal unfair competition claim, fraudulent advertising claim. Those are under federal law, one under a federal statute and one under the federal Constitution. We also filed 5 state law claims under the California Constitution's liberty of speech clause, which is like the First Amendment but has a little broader view of state action, but it's essentially the same. We also filed a claim under the state's Unruh Act, which means you can't discriminate against people for their religious beliefs or for their political beliefs, even if you're not a state actor. But again, state law. And we filed the state UCL claim and then the breach of contract claim you talked about early, also a state law claim. So what you had were 2 claims where the jurisdiction derives from the fact that they're called federal questions, and the federal court gets jurisdiction that way. The other 4 claims are coming in on what's called supplemental or discretionary jurisdiction. Because the federal claims were filed in federal court, we have to file the state court claims in that court so that the one venue hears them, because a federal court, even though it's a court of limited jurisdiction, can hear state law claims as long as it's hearing a federal claims. What happened in our lawsuit was the 2 federal law claims were dismissed. And they were dismissed in large part, and I think most people would agree with it, so that we could take an appeal on a very, very important issue of, does the First Amendment extend to a private property owner who runs a social media site that they have designated as a public forum? And that's an issue of first impression. So that was dismissed so that we could take an appeal. But the court made very clear that the state law claims were being dismissed for an entirely different reason. Quote, "Please go to state court. These are such important issues. I understand," the judge said, "that the issue of the internet and the liberty of speech clause could be a very, very important issue in California because of the difference of California law and federal law about state action. And we think out of comity, which is known as deference to the state law courts, that the state courts should decide issues of their own law and not the federal court." So what's happened is we've taken an appeal to the Ninth Circuit on the merits of the 2 federal law claims, and the state law claims were dismissed without prejudice, and we will file a state law action, as the judge has requested that we do, in a state court and litigate those issues there. So we're now going to have 2-track litigation. If we win in the Ninth Circuit on the 2 federal claims, those 2 claims will go back to the district court and we'll proceed there. But we're going to proceed in state court on the California law claims for exactly the reason the judge said, which is California courts should have the right, at least at first blush, to determine their own law and the scope of their own law.
So obviously you don't have a crystal ball, but I'm going to ask you 2 crystal ball questions. One, how well do you think we'll do on this new state court
I am very passionate about your claims, meaning in my heart and in my brain, I know we are right. That doesn't mean that everybody is going to agree that we are right. So as lawyers, we tend not to handicap things. But I will say this. This is an incredibly unique case, and I think nobody understands how unique this record is and how narrow this case is. This is not a case about whether the internet is going to be subject to all these consumer laws and all that stuff. It's simply about a case where when the internet operator says, we are a public forum, does the First Amendment apply? And if they hold them to that admission, unless they were lying and somehow there's no way to believe what they were saying, I don't see how we can lose, because I don't understand what the dispute is. If they admit that they are something, and that something as a matter of law is subject to the First Amendment, there's nothing left to deal with, other than their right to de-designate that and change the representation. So this is not the case that is going to the Supreme Court about cable access channels and whether or not state laws had made them a state actor. This is not even the cases like Twitter or other places where the mission statements and the representations as consumers are, I'm not going to say they're not First Amendment representations, but they're certainly not as direct as the Google YouTube representations. Google YouTube made a marketing decision for their business purposes to take their own private property and invite the public to use it for one purpose and one purpose only, freedom of expression. When you do that, as a matter of law in the Ninth Circuit and across the country, as a matter of law, if it is a public forum, which they say it is, there's no issue that the regulation of speech by any party in that public forum is subject to First Amendment scrutiny.
I think that really makes the point very clear. It's actually a much simpler case than people think.
Yeah. If you're not a public forum, don't tell people you are, and we go away, right?
Right.
But don't tell us you are and then behave differently. Again,
Right.
I come back to the wine issue. Don't tell me your wine's from Napa when it's from Paso Robles. And then I can make a decision as a consumer in a private market whether I want Paso Robles wine or not. And if I want to pay more for Napa wine, I can. But don't tell me you're selling me a product that you're not selling me a product. And certainly don't do it when the product that you're selling me has constitutional implications.
By the way, we'll put a link to this specific case that you're referencing in our email below.
Right, and just so people know, the case in the Ninth Circuit is Katz versus Lee, which holds that if it is a public forum, a private party who regulates speech in a public forum is by definition doing an exclusive government function, and that regulation is subject to the First Amendment. And that's very important because unlike Google, YouTube, and even unlike some people who are more conservative who are concerned about this case, because they think it's something it's not, they challenge the fact that aren't you saying that because they operate a site that involves communication and they own a site that's communication, they're state actors? Absolutely not. The operation and ownership of that site has nothing to do with the state action claim. The state action claim has to do with the regulation of speech. That is the only thing that we are claiming is state action. You are regulating in speech. Because you've designated your property as a public forum, you can't regulate your speech without the First Amendment. But that's your choice, YouTube. If you don't want that, just take it down. Unrestrict the Prager videos. You can start restricting them going forward. Maybe you're going to have to pay a little compensation for lying to the public and building a multi-billion-dollar or multi-trillion-dollar business off other people's speech, but that's a small price to pay for what you got. If what you're really worried about, YouTube, is that you can't keep your competitive edge, then you need to work with all of us to come up with legitimate types of criteria that will regulate speech effectively, protect compelling state interests, but will do so in a way that isn't subject to viewpoint animus, the concerns of your advertisers, or just the fact that you want a competitive advantage over all those third-party people who built your site in the first place.
Crystal ball question number 2, Supreme Court. You think we're going to be there, get there, need to go there?
Well, we're certainly going to have to file an amicus in the cable case because I'm concerned that case could sweep too broadly because our case is so unique. I mean, the cable cases, the cable companies that are defendants in that case, they didn't say their places were public forum. I mean, even the Twitter and YouTube cases, it's a lot harder to get to the public forum issue than it is in the YouTube case where they've just basically put it out there and said that. So the short answer is we'll have to wait and see. Clearly, if we lose in the Ninth Circuit, we are going to file for cert because I can't imagine that the Supreme Court isn't going to be interested in a case where the owner says the property is one thing and somehow the courts are treating the property differently. I think that's a real problem. And frankly, if I were a private property owner, I'd be worried about that I can designate my property for one thing, but it will be treated differently for purposes of the First Amendment. So I think one way or the other, we're going to end up in that court. It could be as an amici that's a friend of the court in the cable case, just to make sure that, not to take a side in that case, but to make sure that they don't sweep our unique record in with the case where they're trying to determine state action, not based on any representations, but based on the characteristics and other things of the forum. So if we win in the Ninth Circuit, which I'm cautiously optimistic we will, I feel we should. I haven't heard an argument why we shouldn't. The question's going to become whether the court's going to take cert when Google appeals. And my view is, in a case where they're saying it, I'm not sure the court's going to take cert in that, because I don't think there's really, when you break it down on the way we're breaking it down, that fascinating an issue if they go that way, because the response is going to be, you said it. If you don't like it, stop saying it. That's kind of not the type of issue the Supreme Court might take. On the other hand, if they go the other way, where the Ninth Circuit says they said it, but we're not going to hold them to it, we're definitely going to try to get to the Supreme Court. And I think the Supreme Court's going to be very interested in that, because this is the ultimate case for state action. The state action doctrine is whether a party is a state actor that is subject to anything in the Constitution is a very difficult test. It's been changed. There are a lot of different issues. So a lot of these cases, they need to define that. But here is the outer bounds. This is the most state action a private party can get. How do we know that? Because they're telling us to our faces. They're advertising the site as a public forum. I think if we lose in the Ninth Circuit, I think the Supreme Court may have a real issue with that, because the outcome of that case is a private property owner. And for those people who are concerned about the rights of private property owners, this case is going to be known as the case where the private property owner can never designate their property as a public forum, can never designate their property for a public function. And that's outrageous. If a private property owner wants to do that, a private property owner should be able to do it. And if the private property owner doesn't want to do it or wants to change it, it designates.
Mm-hmm. Well, another fascinating conversation with you, Peter. I really appreciate it. Friends, I hope you enjoyed this conversation. If you have any questions, please remember, clarity, transparency is what we're all about. Feel free to send me an email. I'm happy to answer as many questions as you might have. And stay tuned. We are going to put on a serious fight here. So thank you again for your support, and God bless you.
Thank you so much.
Thank you, Peter.